Oh, and I know Glenn asked you to repeat. Well, good evening, everyone. One of you. Goodness gracious. Good evening, everyone. All right, now at least I know you're all awake. That's good. I'm Paul Levengood. I'm president of the Marshall Foundation, and I'm delighted to be with you. This legacy lecture is actually the last one of the season. No, that's not true. There's one in November. All right. See, you didn't want it to end, so we won't end it. And we are really happy that you're here. It's a beautiful day, so I appreciate you coming and spending some time inside here at the Marshall Foundation. As always, a couple of housekeeping items. I am going to take advantage of this being the late in the season to thank the sponsors of the Legacy Series for the past year of programs. Dominion Energy, the Ann Carter and Walter Robbins Jr. Foundation, the Richard and Caroline T. Gwathmey Memorial Trust, Cornerstone Bank, Edward Jones, Raymond James, Connections Plus of Rockbridge County, and the Veterans of Foreign Wars Posts 1499. So please join me in thanking our sponsors. This was great. I hope we get a lot of these sponsors back next year. And if you are in a position of influence with any of those sponsors, you can put in a good word for us. I also wanted to mention again the upgrades in technology. I do this as much for the people online as anything. We have an increasingly growing large audience for these programs through live stream on our YouTube channel. And we've been trying to respond to the need for better lighting, for a better screen, for a better sound, picture quality, and we've, I think, accommodated that. So I welcome everyone online, especially my parents. Last time we were doing this, I said hello to my parents and said I would call them over the weekend. I forgot to call them over the weekend. So I'm not making any promises, but I'm going to say hi to Mom and Dad. And as I did mention, our final legacy lecture of the 2025 season will be here on Thursday, November 13th. And that evening, John Shortle, some of you might remember a lecture he did a couple of years back. General John Shortle will take us back to the early days of World War II and discuss British-American military collaboration in 1942. So please make plans to join us. And finally, if you have one of these, I bet you all have one of these in your pocket, would you please take it out and make sure that it is either silent or off? Because you do not want to be the person frantically trying to silence their phone as it interrupts our speaker. So, on to this evening's program. The International Military Tribunal, established at the end of the war in Europe, was a development without historical precedent. The drama that unfolded during the Nuremberg trials gripped the world with scenes of Nazis in the dock as legal proceedings clinically presented evidence of their crimes against humanity. It's a story that many of us think we know. However, our speaker this evening will reveal that there was much more to it. Dr. Robert W. Hutchinson earned a BA from the University of Delaware, go Blue Hens, and a PhD in modern European history from the University of Maryland. He's held fellowships at the U.S. Holocaust Memorial Museum and the U.S. Naval War College. Currently, he is Associate Professor of Strategy and Security Studies at the School of Advanced Air and Space Studies, Maxwell Air Force Base. At SAS, it's funny to have a SAS, it's, tell your kids, don't sass me, but SAS anyhow. He teaches courses on air power history, military theory, and irregular warfare. His research focuses on 20th century European political and military history, intelligence, and genocide studies. He's the author of German Foreign Intelligence, From Hitler's War to the Cold War, and After Nuremberg, American Clemency for Nazi War Criminals, about which he will speak to us. Please join me in a warm Lexington welcome to Rob Hutchinson.
Thank you all for having me. That was a very generous introduction. I've like immediately forgotten everything I was going to say. But actually, let me start off with the most important thing, because as you said, I work for the Air Force. So the obligatory disclaimer has to occur in that I represent only myself. I do not speak for the Air Force, nor do I speak for the DoD. And that goes double tonight, since given the furlough, it would be illegal for me to speak for DoD anyway, since I'm currently furloughed. So thank you for having me. I'm gonna, I'm very excited on the far left there, his verdict and sentencing being read to him live in April of 1949. He's somewhat atypical of the characters that go on trial at Nuremberg, in that he joins the Nazi Party late. He only joins after the revolution in May of 1933. And he has a background in clothing manufacture and textiles. And so as a result of that, he rises through the ranks and becomes an economic advisor of sorts for kind of governors or Gauleiters in the party. And ultimately, from the mid-30s forward, and then during the war, he becomes the head of the textile division in the Reich Ministry of Economics and chief of the Raw and Basic Material Office in the Reich Ministry for Armaments and War. And you might at this point be thinking, what on earth could this person have? This is the most boring person in the world. How could he be a criminal of any way, shape, or form? Well, like many others, those are just two of his many titles in an authoritarian regime, particularly the Nazi regime. They collect titles and offices as if they were, baseball cards, right? Everyone has many roles to play. In short, what brings Carroll to Nuremberg is that he found himself in a leading position in the state-run textile manufacturing industries during the war, in Austria, in Czechoslovakia, and in the occupied Eastern territories. Among many other duties, he oversaw productions of uniforms for the Wehrmacht, right? A fairly banal undertaking. But how did he do this? And how was this possible? Well, those textile manufactories that he ran or oversaw or administered were forcibly expropriated from their legal owners in Austria and Czechoslovakia and in the occupied Eastern territories, either directly through military force or through coercively. He would go to investors and threaten to unleash the German military unless they sold out at rock bottom prices to the Nazi regime. How did those clothing manufacturers and textile manufacturers run during the war? Well, they ran based on slave labor, through which he advocated for, administered, and allocated throughout his various kind of duties in the Reich. So he not only used slave labor himself, he, in his official position in the Ministry of Economics, helped allocate slave labor for other concerns, whether it's captured prisoners of war or concentration camp inmates and that sort of thing. At Nuremberg, he was convicted of 3 counts of war crimes and crimes against humanity, including one count of atrocities against civilian populations, a second count of plundering and spoliation of occupied territories, a third count of enslavement and deportation of concentration camp prisoners and civilians in the occupied territories for slave labor. And there were also 2 additional counts of membership in a criminal organization because our friend Hans Carroll was in the SS and also a member of the Nazi Party. He was given a sentence of 15 years. For his crimes, which is fairly standard for this trial at this time, a non-military, direct, of an official not directly participating in the murderous activities of, say, the Einsatzgruppen or the concentration camps themselves, but facilitating these activities for others. So that's a story with a beginning, a middle, and an end, right? And that's how we tend to think about trials, right? The beginning is wartime activities where a crime occurs with a certain context. The middle has to do with uncovering these crimes and substantiating them through evidence, and the end is the verdict. That's how dramas like Judgment at Nuremberg work. That's how every episode of Law and Order works. That's how John Grisham novels work at all. When they talk about lawyer drama in between. I study what happens after this discrete story is over, and my argument to you, the argument I put forward in my book, is to think about this not as an ending, but as a beginning of a whole process where the legitimacy of tribunals like Nuremberg, both in terms of their reception in Germany, but also their importance for international law, are litigated again and again and again in public after the verdict is handed down. Because after the lawyers go home and after the press takes their pictures and after Curl goes to prison, there's a whole process of attempts to appeal for leniency, for sentence revisions, for parole, for time off for good conduct, and all of the rest. So, this story does not end with people like Hans Curl in jail. In fact, it really just begins there. From the beginning of the U.S. occupation, Nuremberg is meant to be a part of a larger U.S.-led project of reconstruction and redemption of the German people. And I'll talk a little bit more about that in a few moments. It's a pillar of U.S. occupation policy. And my research book after Nuremberg is meant to kind of look at the period after 1949 when the last trial ends and how this pillar of U.S. occupation policy was eroded over time. Well, we'll just get there. So this is Hans Curl again, referring to his story. Returning to our friend Hans Curl. He's sentenced to 15 years in April of 1949. Here he is crying tears of joy, reuniting with his family less than 2 years later. In February of 1951. I apologize that the image on the right is a little blurry. These are stills from a newsreel footage. And so if you actually later on, if you want to Google like Landsberg War Criminals Freed 1951, you can pull up on YouTube this footage. It's about 1.5 minutes from Reuters and British Pathé, I think is the copyright holder on that. And so here he is released from prison 2 years after being, less than 2 years after being sentenced to 15 years in prison. And so when we think of Nuremberg, we think of the solemn expressions on the faces of defendants and spectators in the galleries. We think of pugnacious attorneys like Benjamin Ferencz, harrowing documentary footage of Nazi atrocities, and the heartbreaking testimony of eyewitnesses to Hitler's project of racial warfare. But Hans Curl and others, because 32 other prisoners were released this day as well, Hans Curl's and others' expression of pure joy and happiness at being released from prison years, sometimes decades ahead of schedule, is just as much a part of the legacy of the Nuremberg trials as any of the previous images I showed you. How is it that a crowning achievement of U.S. occupation policy in dispensing justice to former enemies while affording them the protections of due process under the law was undercut, discarded, and abandoned after 1949? So these are the facts that actually kicked off this project. They didn't kick me, they kicked off the project. Excuse me. And so this is just, the bare facts that started me on my journey, so I thought I'd share them with you. From December 1946 to April 1949, there were 12 Nuremberg tribunals that fined 142 leading officials of the Nazi dictatorship guilty of war crimes and crimes against humanity. They're fair trials. We can talk more about how that's true, but one indication of that being true is that some 36 people are acquitted by the tribunals, which doesn't normally happen in a show trial for victor's justice, that sort of thing, right? So 36 people are acquitted or set free from lack of evidence or mitigating circumstances, but 142 are found guilty. Many of these are given long sentences, but many are also given short sentences of 2, 3, 5 years, something like that. And so by January of 1951, of these 142, 89 are still in jail, serving sentences dating anywhere from 7 years to life in prison or some awaiting execution. And of those 89, 78 received clemency from the U.S. occupation authorities. And all are released by 1958. That includes the commutation of 10 of 15 death sentences, reduction of life sentences to terms of 20 years or 25 years, and outright releases in 1951 that lead to pictures like I just showed you of Hans Curl. And so the big question that I felt compelled to answer for my own kind of edification before it became a book, right, as just a historian, was how did this happen? And why did this happen? Because if we consider Nuremberg, or the treatment of German war criminals as a policy, then how was it that the U.S. went from pursuing a policy of putting German war criminals in jail to a policy of setting them free? Right? This is a pretty big reversal. And so what went into this? And I'll give you some of, oh, wait a minute, no, I won't. I have a second part to that. Apologies. These people, after all, had not committed crimes of passion or opportunity, right? The Nuremberg war criminals had engaged in systematic waging of aggressive wars of conquest. They'd engaged in war crimes, mass murder, torture, enslavement, exploitation of forced labor, plunder, all on a massive scale over years, right? They were the makers and enforcers of criminal policies often carried out by others, but others would not have carried them out if the policies had been not made by these people. So to borrow a phrase from like kind of Christopher Browning when he's describing like the line police officers who are serving in the mass shooting operations in the East, these people aren't ordinary men. They're the elites of the Nazi Empire. The evidence against them was clear and unimpeachable. It was often, most of the evidence was documents signed by them, describing exactly what they had done, captured from the regime's own archives. And this was the point. Those who had designed the trials didn't want to rely overly so on eyewitness testimony, which could be argued about and could be fallible in some ways. They wanted the records of the regime itself to condemn these people. And the records were, for the most part, unimpeachable. As recently as 1949, U.S. military governor Lucius Clay had reviewed almost every single sentence and affirmed them as fair and just and true and worthy of carrying out. And the U.S. Supreme Court had rejected every one of their appeals for lack of jurisdiction to say, no, this is it. This is what it is. And yet, by 1951, they're marching free. And as early as 1942, the Allies themselves had proclaimed publicly their intention to punish perpetrators post-war. And they did so, first at the International Military Tribunal that you mentioned, and then independently in their own occupation zones. There was agreement on this. And so why the reversal? I don't mean to keep hitting you over the head with that, but it's a pretty big reversal in policy. And so how did that happen? And in answering that question, I'll kind of hit you with some of the arguments of the book, and then I'll walk through a couple of examples of what this looked like in practice with some defendants. But in answering that big question of how did this happen, I kind of arrived at four kind of themes or conclusions that my book discusses. This is the part where I try and sell the book. But I'll tell you everything that's in there, so it's fine. But if you want more depressing details, that's where you can get the book itself. So first and foremost, this is a story about justice. And I have up there its contested meanings. But like, what does justice mean in this context if your aim is to achieve justice? Justice could be centered on the victims in terms of exacting retribution or restoring to them some measure of what was taken from them, either physically or not physically, as a result of the Nazis' actions. That's not the focus here. Justice could be abstract in terms of serving as a deterrent in international law. You hit these people over the head with a hammer to make sure that the next war, nobody does this again. And there's a lot of talk about that kind of early on, but it turns out that's not the justice that we're interested in either in the late 1940s and the early 1950s. Most of the main characters in this story that I'm telling you and that I discuss in the book are State Department officials and lawyers all, and they're very preoccupied with the notion of justice that's sense. But how far does that go? And what does it mean to treat war criminals justly? Is it enough to have a fair trial, allow them lawyers and observe rules of evidence and not do a show trial like the Soviets have done? As I told you, they acquitted a number of Nuremberg defendants. But if that's not enough, what else is required? Is justice only done if people can appeal their sentences, as in the American system? How many appeals? To who? Under what circumstances? Based on what? New evidence? Feelings? Vibes? Like what is the criteria through which justice could be done? If you're going to grant clemency to these people, do they need to show remorse? Do they need to be sorry? Do they need to have introspection at all for what they've done? The answer is no, by the way, to all of that. But these are all questions that the characters in my story tie themselves in knots over from 1949 to 1958. Bipartisan, by the way, across multiple administrations, from the Truman administration into the Eisenhower administration, and including both kind of traditional Republicans like John J. McCloy, who are working for Truman in a Democratic administration, but also Democratic appointees under him and Republican appointees later on, right? They're very concerned with what justice means and how to make sure that America is perceived on the international stage as just. And in some ways, I'll talk more about this, that requires relitigating the sentences over and over and over again to prove that they're legitimate. But when you do that, you delegitimize them. The second theme here is this is a story about kind of, this is my other job creeping in, talking about patron-client relationships and so forth in foreign policy. That's the Air Force kind of creeping into my presentation. But it's a story about who has power here and who doesn't. In this period, the US goes from enjoying near absolute sovereignty over German affairs in its occupation zone to turning these authorities over one at a time, beginning in 1949 with the ratification of a West German constitution, and then the last of these kind of sovereign functions returning to West German control in 1955 or so. But even after 1955, the US government enjoys sovereignty over the Nuremberg war criminals. They are wards of the US State Department. Landsberg prison is administered by US personnel. These people cannot be moved from the prison, released from the prison, or nothing can be done in regards to their files or freedom one way or the other unless the US State Department, and then later on after 1955, the ambassador to Germany signs off on it. And so this is important to remember because there are many excellent books on the early history of West Germany. I'm thinking of like Norbert Frye's Konrad Adenauer and the Nazi Past, or Jeffrey Hirsch's Divided Memory, that stress the problems and the trade-offs that the Adenauer government had in the post-war period, because it turns out that the pursuit of justice in a new democracy, these two principles diverge because justice is unpopular in West Germany, right? And so you can't have both. And if you can't have both, what do you choose to pursue? And Konrad Adenauer chooses to pursue democracy because amongst the rightist members of his coalition, he's a leader of the center right and the right. The war crimes trials are incredibly unpopular with veterans organizations, church organizations, et cetera, and so forth. And so the question becomes, well, perhaps the government of Germany is advocating pressure on the United States to make them kind of roll back these sentences, trading political favors and that sort of thing. But in this issue, that's not true. At least if you look at the records very closely, the sources aren't talking about that. No one cares very much about what Konrad Adenauer thinks at all about this, one way or the other. He keeps advocating for freedoms, and he keeps advocating for the Allies to abrogate the Nuremberg sentences, but State Department officials are kind of derisive in terms of their private correspondence about how they talk about this. They kind of toss him bones for show, but they're not really taking his demands seriously, and they don't need to. Because on this matter, right, they have to negotiate with Adenauer on West German military, on the economy, on all number of things. On this particular matter, the Americans are sovereign and can do whatever they want. And so then the question becomes, if that's true, then why did they do this when they could have done any number of other things? And that's the third point, right? If the US was not generally responsive to West German political pressure, why did they act in a certain way with regard to the Nuremberg prisoners? When I first began this research, I expected that I already knew the answer. I thought this policy reversal would have its origins in Cold War stuff, right? After 1950, the Korean War kicks off. All U.S., there's already been a drawdown post-war in the United States and kind of budgetary retrenchment. It's a smaller force. It's a less agile force. The Soviets have conventional superiority in Europe even before the Korean War kicks off. And once the Korean War kicks off, 80% of US forces end up in Korea, and people are terrified that the Soviets will just roll on through. If they wanted to, they could. And so there's a story to be told here where discussions and trying to buy off the West Germans of rearmament, which is actually unpopular in many German domestic policy circles in the 1950s. The idea that, well, West Germany would need to participate in a European defense community or somehow come into NATO. And, unfortunately, there's not enough German resistors who are left alive to fill the ranks of a new German army. So you have to pull on veterans, and the veterans hate Nuremberg. And so that's a deal that has to be struck. This is what I expected to find. And I didn't find that either. It turns out that all of this was set in motion before any of those discussions kicked off. We start down this road of reversing the Nuremberg policy almost immediately after the last trial concludes in 1949. All of these considerations of the hard Cold War with Korea and all of this mostly appear in the correspondence after these things are already in motion. So it turns out that what got the ball rolling was still Cold War related, but it was more domestically focused. It's a story that the Americans are telling themselves. And it has to do with this conception of what John J. McCloy, the US High Commissioner for Germany, and others on his staff think of as American justice, as opposed to Soviet justice. Soviet justice isn't just at all. It's the land of show trials and fake processes and all the rest. But American justice has to be right and true, even if it's unpopular, even if a murderer walks free. A murderer will walk free based on rule of law and all this. And so when it comes to the Nuremberg trials, McCloy comes into office new in 1949, and the first thing he's faced with is he's supposed to carry out 15 executions of people who were tried under Lucius Clay, his predecessor. And McCloy, amongst many other things, he's a man of faith, but he's also kind of a shrewd politician, policymaker, and he wants to make absolutely sure that this is true and just. And so maybe we better take a look at those sentences and make sure before we start executing people. Not just because of the optics of a mass execution, but also, how do we know that justice was done just a few months ago? And when you start down that road, it turns out it's a self-perpetuating cycle, because if you look at it once, well, you can look at it again and again and again and again. And the only logical conclusion of institutions that are set up to handle those sorts of questions is clemency for everyone. And there are also a number of domestic drivers of this. What actually kicked this off, if you're interested in more detail, is some of the people who will play a role in the story of McCarthyism and the Red Scare. Before they do that, their pet issue in Congress are kind of lurid tales of how US military personnel abused German prisoners and coerced confessions in a Soviet manner using Gestapo tactics and all of this. None of this is true, but lots of this is rumored, and it's ginned up, and McCarthy's involved. He has a lot of German constituents, and that sort of thing. And enough controversy is ginned up that there's congressional inquiries, and these congressional inquiries also force McCloy and others in his office to respond and say, with an idea of defending the Nuremberg settlement. Like, no, these confessions weren't extracted through torture or any coercion or things of that nature. We're going to look into this, and we're going to prove that justice was done. And in doing that, he opens up a whole Pandora's box of other things, as we will discuss. Because ultimately, what American justice means is treating war criminals as criminals first and war criminals second. And this whole question of legally, what is a war criminal? How do you treat them, right? Are they entitled to all the protections that someone who robbed a bank in the United States would be given in terms of time off for good behavior, privileges of visitation, appeals, clemency, parole, all of those natures? And so what happens throughout the 1950s is the uncomfortable grafting of American penal institutions onto kind of this unprecedented problem. Because how do you rehabilitate a war criminal? What does that even mean, right? It's an odd kind of conclusion to come to, but that's where this is all going. And finally, this is a story about what happens when a policy shift is received in a manner much different than what was intended. US officials didn't set out to delegitimize Nuremberg, but they did anyway in the eyes of many of the contemporaries internationally. The consistent tinkering with the sentences over and over and over again lent credence to kind of the worst reactionary narratives in the German public, that the trials had been unfair or illegitimate. If they were fair and legitimate, why are you constantly freeing people? Why are you constantly taking years off the sentences? So there's this idea of what these lawyers think they're doing and how that's received in the public. And so they think they're bolstering the legacy of Nuremberg by proving that they're fair, when in reality, what most of the international community takes away from this is that Nuremberg was deeply flawed in some way. And to talk for a minute about kind of the central place of Nuremberg in the US occupation, I just want to step back for a second. So there are 4 pillars, basically, of US occupation policy in Germany. Sometimes they're called the 4 Ds, if you're familiar with that. First is demilitarization, so disarming the German Wehrmacht, but that also means culturally going in there and fixing what's broken, right? Prussian militarism, bad. Germans always invading people, bad. We're going to go in and reform, end the existence of the Wehrmacht, but also root out this Prussian military culture. 2 is denazification, so destroying the Nazi party and delegitimizing its ideology and ideas. 3 is democratization, so kind of rehabilitating Germany along small d democratic lines based on the United States. So multi-party elections, separation of powers, independent judiciary, a constitution that respects individual rights and all of that. And 4, decartelization, breaking up the German economy. This is very progressive era and New Deal era politics, right? Big business is bad. Trust bust, it's a very American thing. And so the idea that if the German economy is very concentrated, full of big kind of cartels, then that's bad for democracy. And so we're going to go in there and break that up as well. And Nuremberg is part of that process. It's designed by Telford Taylor in the Office of Investigation for War Crimes as a way to educate the German people as to the ills of Nazism so that they can reform as good Democrats. Again, small d. Thereafter, the international military tribunals I talked about of the ringleaders of the Nazi state. So the ringleaders who are surviving are all tried by the international community. And then alongside these trials are trials of trials of individual perpetrators by the US Army of low-ranking officials who commit war crimes in the field against US troops or who commit individual acts of brutality in the concentration camps. There's about 1,600 of those trials. They take place at Dachau in the US occupation zone. And this set of trials of Nuremberg, the subsequent military tribunals, are meant to put the state itself on trial. In a provocative phrase that's not mine, but I stole it and I love it, think of these as liberal show trials, in the sense that, hang with me for a second, right? Like, they're totally legitimate. They're first and foremost trials of individuals based on discrete crimes, right? This person used slave labor. We're going to try him for that. That's a violation of international law. So it's a fair trial. It's not a Soviet show trial. But there is a political purpose to it. It's meant to educate people. There are 1,000 defendants you could choose to put on trial, but you choose to put on trial these 170 or 180 or so because they represent all the different facets of the state that you want to prove to the German people are bad in some way. So, case 1, doctors, medical experiments, right? Case 2, the Air Force. Case 3, the judges and the courts. Case 4, the SS concentration camps. Case 5, iron and steel industry, chemical industry. You've got a couple of trials for the military in there, both in the Balkans and the Eastern Front. You've got the SS kind of race and resettlement main office, which is concerned with ethnic cleansing within Germany, but also in the occupied territories. You've got the mobile killing units. The ministry's trial, where Hans Kurl was tried, was meant to show that the civil service itself had been corrupted by Nazism, and on and on. And so these trials are first and foremost, as I said, fair trials of individuals who committed crimes, but in the whole, they're supposed to educate the German population. And as part of the occupation, all the transcripts were going to be translated and disseminated and made public. They were meant to be covered extensively in the press. This is how the trials are a classroom in which you educate and redeem the German people. That's what they were designed to do. And so this makes their delegitimization later kind of a bigger issue than would otherwise been the case because of this role they were supposed to play, pillar of US occupation policy. So this is John J. McCloy in his office, the US High Commissioner for Germany in early 1950, and he institutes a number of reforms that are self-perpetuating based on his staff and his idea of, as I mentioned earlier, American justice. The idea is that there's a flaw in their view in what happened at Nuremberg, because American justice doesn't only mean the right to a fair trial, it also means the right to appeal your sentence, which that's somewhat controversial. It goes further than many contemporaries at the time would go. You have the right to a trial, you have the right to a trial by jury, you have the right to face your accusers. You don't have a right to perpetually appeal this verdict forever, right? So there's an intellectual leap that's going on there, and McCloy is very confident. A lot of this is driven by him personally, as a lawyer himself. Like, he wants this to be done. No appeals court existed because Nuremberg is a new thing. International law is a new thing. The institutions do not exist. There's no power to create them anymore because of the Cold War. The statutory authorities governing the US occupation are set, so you can't invent new institutions. But what you can do is use existing powers in a way that gets at what you want. And what McCloy doesn't have, he doesn't have an appellate court, but he does have clemency powers delegated to him from President Truman, because John McCloy is basically king of American-occupied Germany. And he's acting on direct authority of the president, and so he enjoys the plenary pardon power that has existed in the US executive since the founding of the Constitution, right? To grant mercy for crimes. And so using this power, he assembles a board, an advisory board on clemency, to evaluate whether Nuremberg had delivered justice or not and whether the sentences should be reduced. And there's a major issue with this because it turns out a clemency panel and an appellate court are two very different things. And to have a clemency panel act as an appellate court sets you up for some very serious problems. So what does a clemency panel do and what does it not do? A clemency panel reads the judgments. The judgments are based on thousands of pages of testimony, documents, evidence, exhibits, and all the rest. And then the judge writes like a 10-page summary about why this person is guilty, sometimes with reference to one particular piece of evidence that's very powerful or something. If it was an appellate court, you would examine all of the evidentiary record. A clemency panel just reads the judgments. An appellate court would have opposing counsel. There'd be voices from the prosecution arguing with voices of the defense. There'd be a way to evaluate whether new evidence that's introduced is nonsense or real. A clemency panel doesn't have the resources for that. It's three guys in a room. And what they do is they read the judgment. They have a 30-minute meeting. Only defense counsel's there. They are kind of credulous and interested in hearing stories about German suffering and unfairness. And without reference to the full documentary record on which the judgments are based, they're inclined to agree with the German. So a German will come in, and a worker will come in and say, this wasn't me, it was my supervisor, made me do this. And they will have made that same argument at trial, and the judge rejected it at trial. The superior orders defense doesn't cut ice at Nuremberg. But the clemency panel, it did. And so they say, well, maybe he's responsible, but not quite as responsible as he would have been otherwise. And this sets up kind of this process of benefit of the doubt, right? And it also sets up this process of, I don't want to reduce it to if you give a mouse a cookie problem, but so first, every policy in and of itself as a discrete action is reasonable. Let's account for pretrial confinement. That makes sense. Right? Some of these people are arrested in 1945 and don't go to trial until 1948. So let's cut that time off their sentences. Okay, we've done that. Well, in the US system, every inmate gets 10 days off per 30 days for good behavior. Should we institute that? Well, that makes sense. It would be unfair or unjust not to do that. What about medical parole for the sick? What about general parole for people who have served 2/3 of their sentences? And you can see how, with these magical calculations of one after another, a 25-year sentence becomes 6 years and a day. Because who are these people? Do you think they're going to misbehave in prison? They're high-ranking, kind of middle-class bureaucrats. They're not the stereotypical criminal. And so when it comes to questions of whether they have been rehabilitated or not, what indicators are there that this is the case? They would have never committed these crimes outside of the Nazi dictatorship. Some of these people were lawyers before the Nazi dictatorship, then the Nazi dictatorship happens, and so they become lawyers and also killers, and then the Nazi dictatorship goes away and they're lawyers again. They have been successfully rehabilitated, right? And I'm not trying to be too breezy about this because this is a very kind of harrowing story, but the kind of logical contradictions and the leaps that when we talk about it this way, I highlight them just to underscore that this didn't occur to these people at the time, right? They were taking each issue as it, I keep hitting the microphone. They were taking each issue as it emerged and not looking at the big picture. And so when you have a scene with 30-some individuals released, you get political cartoons in 1951, mass international outrage, and this is a Herblock cartoon from the Washington Post of McCloy letting Alfred Krupp, the armaments manufacturer, out of prison, while a Soviet propagandist gleefully snaps a photo because the Soviets make all sorts of hay out of this. Like, this just confirms all of their narratives, right? That new fascists, same as the old fascists, all fascists sticking together, American fascists letting German fascists out of jail to make weapons to make war against the Soviet Union. It's all, of course, nonsense, but that's the propaganda line they run with. Allies are confounded. The British and the French have their own war criminals in prison who are now clamoring for the same sorts of privileges that the Americans have granted theirs. So they're going to be forced to deal with this issue. Victims organizations, the World Jewish Congress, obviously apoplectic about this. Human rights advocates, Eleanor Roosevelt, Telford Taylor, all the prosecutors from the trials are dismayed, disheartened, discouraged, and otherwise upset about what McCloy has done. McCloy is unbowed through any of this criticism. He is one of these frustrating figures of a man with deep inner convictions, and we often encounter these people even today in politics where if everyone's mad at me, I must be doing something right. Or it's like, well, maybe everyone's mad at you because you're not doing something right. But that doesn't make a dent for McCloy. And so how does this look, kind of on an individual basis? I want to take just a few minutes and run through what the consequences of this are and illustrate a couple cases. So this is Walter Blum. He had commanded a mobile killing unit, 7A of Einsatzgruppe B, from May to August of 1941, which operated in Belarus. He had received a death sentence at Nuremberg because he had admitted culpability for the stand. He admitted this. And the real number was probably in the thousands, but he took responsibility for at least 200 or so. He had claimed at trial that the reason he only commanded this unit for 2 months, 1.5 of which it hadn't even been activated yet because the invasion's not until June. From June to August is 2 months. He claimed that his time in the field was so short because he had vehemently objected to murdering innocent people and had thus gotten a transfer. The court had adjudicated this claim and found it not convincing. And so he received a life sentence. The 1950 Clemency Board, based on nothing but kind of regurgitated affidavits from the actual trial itself that had already been dismissed by the court, said 20 years would be better. And so life maybe not warranted, 20 years. He did object after all, and that would be reasonable. McCloy thought, okay, and so 25 years for Walter Blum. So we'll split the difference. But when you took pretrial confinement into account, a third sentence reduction for good behavior, the eligibility of parole after remaining 2/3 of the sentence, Blum was paroled in November of 1954. So an admitted murderer on the stand in 1948, life in prison, paroled in 1954. His parole supervisor visited him and found him resentful, unrepentant, and convinced of his own innocence, and actually very frustrated. He told his parole supervisor that, he was forbidden from practicing law in the post-war period. He had been a lawyer before the war. And so now he was just a clerk in a law office. And he resented the fact that he had to take orders from the type of people who shirked away from doing the hard tasks during the war that he had done. And now he was, they were bossing him around in the post-war period. Okay, Einsatzgruppen murderers are easy targets for me, right? That's outrageous. What about other people who didn't kind of resort to that sort of extremes of criminality? This is Heinz Karl Fanslau. You already know the end of this story because this is his parole file. So Heinz Karl Fanslau was an administrator who worked for the SS Economic and Administrative Main Office. This is the WVHA. It ran all the concentration camps empires. And Fanslau was an administrator, he was a personnel guy. He rose to be a brigadier general in the SS, and by 1943, he was in charge of the personnel office of the SS main administrative office. And so what that meant was is that he hired, fired, transferred, promoted, and recruited all the men and women who carried out Germany's project of slave labor and mass murder in the concentration camps. Trial 4 sentenced Fanslau to 25 years in prison, saying in judgment, quote, "Personnel were just as important and essential in the whole nefarious plan as barbed wire, watchdogs, and gas chambers. The successful operation of the camps required the coordination of men and materials, and Fanslau provided the men." But the 1950 clemency panel lingered on the fact that Fanslau had a boss, right? Because he was not an agency head, he was an agency deputy. His boss was Oswald Pohl, the head of the whole office, the WVHA, and Oswald Pohl had been tried at the same trial Fanslau had been tried at and was sentenced to death for being the head of the enterprise and driving the slave labor program in the concentration camps. And that sentence was his crimes were so egregious that sentence was actually carried out in 1951. Pohl was executed. But Fanslau can now point to Pohl and say that he was the one who was really in charge. I just hired people. This is not directly involved in the atrocities and so forth. And so the clemency panel argues that his sentence should be reduced. And it's reduced to 15 years, even though the judges at Nuremberg had already kind of litigated the idea of individual responsibility versus higher responsibility and found those claims wanting. And so like Blum, Fanslau was also paroled in March of 1954 and released from supervision in 1955. And finally, as an illustration of this is even the people whose crimes were so egregious, those 11 or 12 who weren't granted any clemency at all in 1950, still benefited from all the bureaucratic machinery that was set up to administer the clemency and parole program. This is Hermann Reinecke. Hermann Reinecke was a Wehrmacht general who had a number of complicated titles, including Chief of the General Wehrmacht Office and Chief of the National Socialist Guidance Staff of the Oberkommando der Wehrmacht. In practice, he was responsible for ideological indoctrination of officers and soldiers, and he also administered the empire of prisoner of war camps, particularly in the Soviet Union. On his watch, 3 million out of 5 million Soviet POWs died of starvation and neglect, which was not an accident, it was a systematic policy. These crimes were so egregious that McCloy refused to grant Reinecke clemency, which I think was the correct outcome, particularly with reference to his wartime fanaticism, where he was judged by the tribunal as a supine instrument of Hitler's will. The 1950 Clemency Board had recommended a reduction of sentence, but McCloy held firm and said no. But by 1954, additional clemency panels decided that Reinecke should be cut loose on the grounds of essentially cruel and unusual punishment, because other generals of similar rank had already been granted clemency and were already free. And to continue to imprison this one while the others were free was arbitrary and therefore unjust. And so he was paroled in 1954. He lived until 1973 as a free man in West Germany. So to close, I just want to close with an image of this is Landsberg prison where the war criminals were held. And in 1958, the last 3 American prisoners, all Einsatzgruppen commanders, all kind of convicted mass murderers, are set free. And they're set free on the same argument as Reinecke was, that everyone else had already gone free. And so to keep these 3 serving their life sentences was arbitrary and kind of capricious, regardless, without reference to the crimes they'd actually committed or the trial files that had sent them there. And so I ask you to consider, kind of in closing, like what is the meaning of an empty prison and what is the meaning of justice in international law, right? Concepts of rehabilitative justice don't mix easily with war crimes because how does one rehabilitate a war criminal, especially these people whose crimes were related to a system of government and dictatorship that was no longer there? These people weren't criminals before the Nazi regime, they were criminals during it, and afterwards, to keep them in prison would mean that you're advocating for a justice system that is purely punitive because their imprisonment serves no purpose other than that. And is that enough for you? And yeah, I agree. But that's the question, right? Because for a number of very smart people whose positions I tried to move through quickly, but without kind of, while paying respect to what they thought of. A lot of very smart people were deeply troubled by that issue because American criminal justice had moved towards a rehabilitative framework during the progressive era. And if you're going to treat these people like you treat normal criminals, then these are the things that you do. And so what's the legacy of that, and what are the greater consequences of that? Contemporaries certainly thought that McCloy and his staff traded the legacy of Nuremberg and its importance as a guiding principle in international law, but also its, what's the word I'm looking for? Its manner of deterring future crimes for their vision of justice. And I think the best marker to close is reflected in German public opinion at the time. In 1949, most Germans believed in the legitimacy of the Nuremberg trials. By the time the American clemency program is complete, most believe it was illegitimate. And because of the way that this all played out in public. So thank you very much for your attention. I'm happy to answer any questions you might have. The Soviet Union gets a kick out of it, but you know, I don't mean to be too glib about that, but yeah, this is widely covered throughout January and February of 1951. It causes a great media firestorm. A lot of politicians are called to comment on it. There's resolutions in the House and the congressional record. It stirs up a great deal of controversy in both public and private. Yes, sir.
Did Japanese war criminals have a similar thing with somebody to save them from their atrocities?
Yes, actually, a number of folks from the State Department who work the German portfolio. Oh, sorry. Yep. Got it. I have the note and everything about repeating the question. I did the first time, not the second time. Sorry. The question was about whether there's a similar kind of process unfolding in Japan. And the answer is yes. I'm not an expert in this, but I talk about it a little bit. It happens a little bit later, starting in 1952 or so. And it's some of the same people in the State Department who are working the Germany portfolio in 1950, then start working the Japanese war crimes issue in 1952. And in fact, a member of the first clemency board, Conrad Snow, State Department hand, is on the same board in Japan and brings his expertise to bear there. And so the Japanese clemency proceeds along the same lines as the German model. The German model went first. And again, I didn't go deep into those records, but just in what I did encounter, the motivating factors appear to be the same, right? It's not as much hard power, Cold War stuff about securing US bases for Korea or something like that, as it is justice and making sure justice is done, narrowly defined. I'm sorry, I ignored you like twice.
No, did you find any connection between this activity and the Operation Paperclip high value German or Nazis that were of such value to this country? They may have been legally culpable, but they were brought to this country for higher purposes. Is there a connection there?
Yeah, yes. It's a yes, but, right? So a number of the questions about paperclip and connections between this process and that process and extracting high-value Nazi scientists and so forth. A couple of I think it's 2 or 3, or 1 to 3, it's at least 1, and possibly as many as 3, figures who were processed as a result of the medical trial. Particularly the chief of Air Force Medicine ends up here as part of the paperclip program. They had done kind of human experiments and that sort of thing, testing pressure suits, testing on concentration camp inmates, like what happens if you raise the pressure in the room to evaluate flight, medical issues. And then also hypothermia experiments, like how long can a pilot stay in cold water of such temperature before they start. So at least one of those individuals who was tried at Nuremberg became part of that program. It wasn't directly connected in terms of like the policy aspects of it. And those programs too came from a different kind of mindset. Like that was very much, these people have technical knowledge that as a national security risk, we need to prevent the Russians from having, because the Russians had a similar extractive program, even though the American program started first. Whereas this is kind of motivated more by these ideals of what justice means and how best to ensure fairness on the world stage. Sorry, it's over here.
I'm curious about how, what your view of people, different categories of people will view your work, your book. And I'm going to give you 4 different categories.
Oh boy.
One of those is the people in this room, most of us either lived during the conclusion of World War II or shortly thereafter.
Mhm.
Another category would be your average college student today. And then the other 2 categories would be the same generations of people that are in Germany today. So I'm curious about how those various groups would view your work.
That's a great question. Okay, so the question is like 4 categories, how they would view my work. Kind of a generation close to the war, subsequent generations in Germany, and undergrad. I'll start with undergrads. I would be delighted if any of them were interested in anything I have to say. And I appreciate very much, I love them for being interested, if they're interested. I think all of there would be a commonality, right? Like, on the one, the story I'm telling isn't a brand new story. It is just, it's a matter of framing, right? It's like this story, for many others, is a footnote to the real story, which is Nuremberg and the trials. And for me, this isn't a footnote. This is, the broader story extends to this. This is it's not supplanting the other story. It's just saying you can't make sense of the first story unless we view it as a whole, right? From the beginning where in 1942 people are talking about trying war crimes until the end, which is 1958 when the last war criminal walks free. Like, that's a whole story. And so I would hope people would think about that and what it means to kind of reframe the perception there in terms of how it would be perceived. I mean, this is a fun project to talk about because I can be sort of funny, and I can, a number of you have the reaction of like, how could people do this? What on earth were they thinking? Because it seems so obvious to us that this is wrong. And so what's interesting to me is how so many smart people who worked very hard on this could come to an opposite conclusion. And I would hope that anyone who'd be interested in this for the scholarly reason would be interested not just in terms of revealing a piece of history that they don't know, but also this broader importance of it and what it means and how we tend to think about things. Now, as far as German historiography and memory of this, like I think based on my assessment of the recent literature, public opinion is kind of in Germany has kind of come back around on the Nuremberg trials. There's still some folks who would argue it was victor's justice and not legitimate, much like there are many folks in Japan who continue to argue that the Tokyo tribunals and others were illegitimate exercises in victor's justice. But that is not the official position in terms of how history is taught. And so there's hope there for sure. Yeah.
I think your story continues in this question about what is justice. Look at KLM down in Guantanamo Bay and the demise of the military commission process and the inability to try the man even. I mean, 3,000 people are dead.
Yeah, I mean, and these questions are, as you said, there's a comment about Guantanamo Bay and some of the post 9/11 tribunals or lack of tribunals, and these are immensely complicated questions, right? It's and not just as a matter of law, and one thing I'll use that as one thing that I was struck about this is I'm not a lawyer, I'm a historian, right? And so I do not judge these people for thinking like lawyers, right? But this is, in my view, this book kind of is an example of the most terminal case of lawyer brain that is ever kind of, it's just amazing to think about, where it's just by looking so narrow at questions of precedent and law and facts that you're so deep in that you miss the entire big picture of what you're doing or not doing and how that's perceived or how others will perceive that or not perceive it. And there are times when I wanted to reach in there and like wring the necks of my sources and be like, what are you doing? Why are you doing this? But that's not to say that it's easy to sit in kind of judgment, right? Like the difficulty of being a historian is kind of practicing that empathy where you have to say like, well, what are these people concerned about and why? What's an overarching concern for them? And they were really concerned that, injustice had been done. And so in crusading against injustice, they ended up kind of perpetrating their own version of it, which I thought was kind of a very interesting and sad story. Yeah.
What, if any, influence or role did General Marshall
play in this whole scenario?
Yeah, this sounds like I'm being funny on purpose, like none whatsoever. No, I'm delighted to be here. By the time these policies that I talk about start rolling, he is kind of retired from politics and State Department. He would have been of the generation, though, much like Lucius Clay was of the generation of the military officers, Eisenhower, Clay, who had been on the ground, did not waver in their conviction that these people belonged in jail, regardless of whether there were procedural irregularities or not. And there weren't procedural irregularities. I want to be clear about that because that became a canard, so there were not. But even if there were, people like Lucius Clay was like, nope, hang him, no problem with that at all. And so, you know, it's the later reflection that time and distance adds to this, an extra dimension of consideration that many of the figures such as Marshall wouldn't have thought deeply about this at the time while it was going on. Sorry, yes?
So some of the narrative around the Universal Declaration of Human Rights is that it's this like immediate international outcry after deliberation of the camps and the trials. There's also a lot of components of it about fair trials and due process. I'm wondering if part of the clemency process is kind of inspired by that, like if in trying to prevent similar atrocities, they also paved the way for letting a lot of the perpetrators free.
Yeah, and that speaks to this idea of American justice. And what does that mean, right? It means that better many guilty men should go free than one innocent person be in prison. And so this is an example of, if you believe that to be true, this is a cost you're willing to pay. Now, none of these people were innocent. Like that's the sticking point. And the evidence is so overwhelming in so many cases that a lot of the evasions of responsibility are just playing word games. And to your point about like human rights discourse and all of that, luminaries of human rights, Eleanor Roosevelt was incensed by this. She wrote a personal letter to John McCloy. It upset him very deeply. She wrote a private response and a public response where she took him to task for all of this. And in her daily column, or weekly column, I think, she said, she put it in a way that really upset him. She's like, why are we freeing so many Nazis these days? And he was highly kind of offended and shaken. Henry Morgenthau, other people confronted McCloy behind the scenes, and he was unbowed and determined to say, like, no, justice means turning over every rock, giving these people every opportunity, every benefit of the doubt to prove that they are, if not innocent, then at least not as guilty as we had assumed. And so, yeah, it's a great point that the human rights discourse and this aren't incompatible. Yeah.
One final question, right there.
Yeah, I'm really curious about your historical or historian's perspective on John J. McCloy.
Mm-hmm.
John J. McCloy.
Oh boy,
What's the question?
what's the question? The question is my perspective on John J. McCloy. Full disclosure, my wife is a scholar of Japanese American internment. So you might know where this is going. John J. McCloy is a fascinating character because I'm going to choose to be glib and kind of catty about this. He just makes so many wrong decisions. Like every controversial decision that you might be upset about, I guarantee you John J. McCloy was involved in some. John J. McCloy was involved in do we bomb Auschwitz? No. John J. McCloy was highly involved in Japanese American incarceration. Do we do that as a security risk? Yes. John J. McCloy did this. John J. McCloy also did some stuff during the Kennedy administration about nuclear disarmament in Cuba that was kind of like, what are you doing? But what I found out that was fascinating, because there was a biography of him written in '92, I think, by like Kai Bird. It's great. I think it's called like a Man of the Establishment or something. But this is one of those figures, right? Unique almost to turn of the century American politics, where he's an establishment guy. He goes to Harvard. He's a Harvard man, and then he gets into these circles, and he stays in government for so long, and he's consulted by policymakers of both parties. Like he's not a Kissinger type figure, but he's ever present. And so my assessment of him is like reading his private correspondence and his personal correspondence on this issue. I think my personal perspective would be, I think he made a series of ill-advised decisions. But on other issues, he would say things that have me, I've read some of his speeches to the Germans that would have me at my feet clapping, where I did it again, at my feet clapping. Like there's an industry club meeting, I think it's 1949 or 1950, where a bunch of Germans are whining about like tariffs, or not tariffs, the prices of goods and the encroachment of U.S. economic policy and all this. And he yells at them all. Like, these are the industrial leaders of Germany. And he's like, who started the war? Why are American taxes so high? It's because you guys did this. And whether you did this individually or not, it's not right. And you're being restructured now. And then he ends this like upbraiding by saying, like, don't cry in your beer. Think of the good things as they come to you. And so he is incredibly firm. He's not wishy-washy on the idea of Germans and rehabilitating them. He's not wishy-washy on the occupation. He believes in the spirit of Nuremberg in a way, which makes him all the more interesting in terms of the effects that his actions have on the legitimacy of the trial. So yeah, he's a complicated figure, McCloy, and very fascinating. And Kai Bird's biography is great, but I think someone should do an update too, since he lived such a long and fruitful life.
I know there are probably more questions. Rob's book is available upstairs. He'll be signing it, and I'm sure he'd be happy to answer more.
Thank you.